Hello folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we are continuing with the winding up of the companies under the provisions of Companies Act 1956, right? So in the previous lecture we have already discussed in detail about the creditors voluntary winding up, right? And with that we have already covered 65-70% of the chapter. We have dealt in detail about the compulsory winding up, we have dealt in detail about the voluntary winding up, being the members voluntary winding up as well as the creditors voluntary winding up, right? But there are some related topic to that voluntary winding up that are still pending with us, like the committee of inspection under the creditors voluntary winding up that we were discussing in the previous lecture, right? I just gave you the gist. It was just a link, just a hookup to say that yes, we have a concept of the committee of inspection, right? But we did not discuss the details about that committee. How is it prepared? Who are the members? How will it act? What are its powers? None of it, right? We do not know what the committee of inspection is. So the basic consideration for today's lecture would be the discussion on the committee of inspection under the creditors voluntary winding up. Why do I specify creditors voluntary winding up? Was it actually needed? No, because you do not need a committee of inspection in the members voluntary winding up. But yeah, again, if you move out of the ambit of voluntary winding up, then you see that this concept is also covered under the compulsory winding up by the court. Over there also, in order to check the working of the liquidator, to put a check on it, to put a cross check on it, you have the committee of inspection working, right, with 12 members over there in proportion with the members of the committee and with the members of the creditors and the members of the company, right? Both of them could be a part of this with this committee of inspection, right, in any proportion. There's no issue with that. So our lecture basically will be divided into two sections. One is about the formation of the committee of inspection and the other is about the working of the committee of inspection, right? So as we know that the committee of inspection is basically framed in the case of creditors voluntary winding up, right? So once the creditors have decided that they want a committee of inspection, they will appoint one. And when they appoint a committee of inspection, they will have to associate certain members to that committee. They will have to nominate certain members to the committee, right? So the creditor in the creditors meeting, when they are bringing forward the concept of the committee of inspection, along with that concept, they will also nominate 5 creditors from the entire group of creditors that they are setting over there. They'll nominate 5 creditors who will take charge. When I talk about taking charge, is that they will take charge of the liquidation process. If you need anything spontaneously over there, the committee of inspection will be present. If you want to have a check on the working of the liquidator, the committee of inspection will be present. If the liquidator is disposing of any asset, the committee of inspection will check it. If the liquidator is bringing in some fund from the contributory, the committee of inspection will keep a record and the track of where the money is flowing, right? So basically the committee of inspection is prepared to inspect the working of the liquidator in the case of the winding up of the companies, right? So creditors are not the only people who appoint members to this committee. No, the committee will not be under the entire control, 100% control of the creditors. So for that purpose, it is said that when you prepare this committee, the committee of inspection, you will have to have members from both ends. When we talk about the members from both ends, it is the members from the creditors and the members from the members of the company as well, right? So when you talk about it over here, it unlike the provisions contained in the compulsory winding up where you had 12 members and in any proportion, that means 1 the creditor and the 11 from the members, even that could be possible. But over here you can have a maximum of 5 members from the creditor and maximum of 5 members from the members of the company. So that means, as per the statement on the screen, the creditors and the members, they appoint 5 each, 5 and 5 members in the committee of inspection. So that is all about the appointment scheme, right? But now you also need to understand that when management or when the members are going forward to appoint a member into the committee of inspection, that appointment can be challenged by the creditors. The creditors can say that yes, we do not want this person inside. We do not want this member to be part of this committee because maybe they did not have a good experience with that member, or maybe that member is very regressive. There can be any reason, right, where they decide and they say that we do not agree with this member being on board in the committee of inspection, right? So what do you think? Will the request of the creditors be tenable? It depends upon the situation of the case, right? So one more thing we need to understand is not only they restrict that person from getting appointed, they can also by themselves appoint someone else from that group of members or from that group of members of the company to become the member of the committee of inspection. So my dear friends, please remember that in this situation when the creditor is actually trying to put a limitation on the power of the members, right, when he's trying to restrict the appointment of the members of an important member, right, or trying to appoint some other member in his place, this power by the creditor cannot be exercisable, which means this does not mean that they do not have the power to, right, or object or appoint someone else. No, they can do that. But if ever they want to do that, they will have to do that under the supervision of the court. If they want to object the appointment of any member into the committee of inspection, they will have to raise the matter and refer it to the court. So what would be the effect if the creditors they object? Then the member on whom the objection is raised, that member will not act as a member of this committee unless and until the court directs the company to do so, right? So the court has the power that he can direct and say that the member's nominee shall be taken in the committee. So the creditor's objection is overruled. Whosoever is the person whom the member appointed, that member or that person, right, he shall be taken in the committee of inspection. And in case the court says that okay, the nominee of the member will not be allowed to be a part, but instead, the nominee of the creditor can go, right? So in that case, there has to be one other person who shall act in the committee instead of the nominee of the creditor. So when the nominee from the members have been rejected, the court may not necessarily appoint the nomination of the creditor, but instead go ahead and check some other person who is eligible to take this position and then appoint that person to be the part of the committee of inspection, right? That is what we have seen, the objection on the appointment and intervention of the court, right? Now we move ahead to the procedural part of the committee of inspection, right? Now you have seen that okay, the committee has been prepared, the members have been appointed by the creditors, the members have also been appointed by the members of the company, right? So now in your committee of inspection you have people from the members of the company also and from the creditors of the company as well. So what do you think? How many times do they meet? Like for board meeting, you have to have minimum board meetings in a year, one each quarter and something like that, right? You had some certain provisions like that. So do you think there is a compulsion on the minimum number of meetings or the duration of meeting or the distance of the meeting or anything like that? Then the Act says that there is no compulsion in the meeting of the members of the committee of inspection. So if there is anything that somebody specifically wants to convey, then he can call for that meeting. He can call the committee of inspection to sit down and read about it, to sit down and understand, to sit down and discuss, right? So all the meetings of the committee of inspection would be held with the prior approval of the members or the creditors who are calling the meeting. So there is no fixed duration, there is no fixed time, no fixed number of meetings during the year. At every time when they meet, they will decide okay, next when they are meeting. Or in between, if there is any member or any creditor who is a part of the committee, he feels that no, we need to call a meeting because there is some certain matter that has popped up and needs to be discussed, that needs to be tackled, right? So that will also be included in the committee of inspection. That fact that yes, the meeting is not compulsory. You can have n number of meetings, you can have any meeting at any time, any duration, right? So if you look at your screen, it says that no fixed meeting can be called from time to time whenever they deem fit. Now, since the committee consists of members from the member of the company as well as the members of the creditors, I mean the creditors of the company. So when there are two parties, basically two contradictory parties, because one is the contributory and the other is the receiver, the creditor. So one gives and the other takes, right? So there can be a conflict of interest in both of them, right? So how do you decide any matter in the committee of inspection? So basically, whenever there has to be taken whenever the decision has to be taken, the decision will be taken based on the majority vote. The decision will be taken by the majority. So whatever the majority of that committee says, that will be performed, right? And since they have a maximum of 10 members, as we have seen, 5 from the members and 5 from the creditors. So whatever be the number of the members in the committee of inspection, the quorum will always be 1/3 or 2, whichever is lower, whichever is higher. That would be the quorum. So if you want to have any meeting of the committee of inspection, you will have to make sure that the quorum is fulfilled. Without the quorum, you will not be able to hold the meeting, right? And also understand that the accounts that you have prepared, the accounts that the liquidator has prepared, whatever it is, the members and the creditors separately, they have the authority to inspect them, right? Whenever you have any accounts prepared, you always know that yes, it is open for the contributories, it is open for the creditors. So when we are talking about the committee of inspection, we need to understand that this committee consists of 2 categories of people, and exactly the 2 categories whom we have given the right to inspection, that is the creditors and the members. So if the same people are appointed in this committee, so even the committee should be allowed, right? So the committee of inspection is definitely allowed the right to inspect the accounts, right? So you have on the screen that the quorum would be 1/3 of the total number of members and would act by majority. Okay, we have done that. Now we move on to the last part of the committee of inspection that we need to discuss, which is the ground of cessation of membership and filling of the vacancies. So what are the grounds of cessation of the membership basically? So the first ground that is very common is the resignation. So at any point of time, any member of the committee, may he be the creditor, may he be the member of the company, if they want to resign from the post or from the committee of inspection, they can do so by writing a resignation, signing the document and handing it over to the liquidator of the company, right? That is how you cease to be a member of the committee of inspection, right? Second reason of the vacancy or cessation of membership over there is the insolvency or the compounding. So at any point of time, right, if that member of the committee, if any member of the committee is adjudicated to be insolvent, then in that situation only, that person who has been declared to be insolvent ceases to hold the office, ceases to hold the membership, right? Or even if he is not insolvent, but he has been alleged that yes, he has entered into some kind of a compounding with one person or the other, and even in that case, he will not be allowed, right? So now you know that there can be 1 or 2 meetings in the year, there can be a number of meetings in the year depending upon the facts and circumstances, right? So over there also you have a provision that if you are absent from 5 consecutive meetings without taking the leave, then you would be kicked out of that committee. That would result in the cessation of your membership. If you have missed out 5 meetings out of as many meetings, 5 consecutive meetings, if you miss out, then your name is struck off. And the last part in it is the removal. So we have seen resignation, we have seen insolvency and compounding, and we have seen absence from 5 consecutive meetings. And the last portion is removal. Now who is allowed to remove? Because this committee of inspection consists of a homogeneous mix of the creditors as well as the members. So who would have the authority to remove them? To remove the member of the committee of inspection. So in this case also we will get into the details and then understand, right, that the power of removal is not vested upon any one person, because in that committee you don't have any single category. You have a homogeneous mixture of 2 kinds of people. One is the creditors and the other is the member of the company, right? So if you want to remove any creditor from that homogeneous mixture, then you will call the meeting of the creditors of the company, so that in that meeting you can decide whether or not to continue with the creditor, right? And if you decide that okay, all the creditors are good, then again you will have to, and then you want to remove a member, then in that situation you will have to call the meeting of the members and show it to them and say that okay, this is what I don't want, and so I'm resigning from this place. Or actually they want to remove you, so they are conducting the meeting, they're holding the meeting so that they can remove you, right? And for this purpose they will just pass an ordinary resolution. They do not need any special resolution to remove any member from the committee of inspection, and that can be done in the meeting only if there was a notice given 7 days prior to that meeting, and in that notice it was specified that yes, we are planning to do this. We are planning to either remove somebody, we are planning to like seize the office, or otherwise also there is resignation, there is insolvency, there is absent from 5 consecutive meetings, right? So in that case the notice for that meeting the 7 days notice, the notice would be 7 days notice, right, to call the meeting of the creditors or the members. So that was about the cessation of the membership. Now what about the filling back of those vacancies? So for filling back of those vacancies, right, the vacancy that is occurring in the committee, the liquidator has the power to call the meeting of the creditors or the contributories. And he would call that meeting for one specific purpose, that is for filling up this vacancy. And that meeting would either reappoint the same person again or appoint somebody else, right? It depends. It depends on that meeting, the meeting of the creditors, the meeting of the members. So, and if there is a vacancy in the committee, does the committee stop functioning? The answer is no. So far as the committee has 2 members, minimum 2 members, the committee can function. But yeah, if at any point of time that falls even below 2 members, that means you have only 1 member, then that committee cannot perform, because that does not become a committee now, right? If you want to have a committee of inspection, then in that committee you will have to have at least 2 shareholders or at least 2 members of the company. So folks, that is all about the committee of inspection that we wanted to discuss, right? I will take you briefly through it once again. That is, the committee of inspection would be created by the creditors, and it is basically created in the creditors voluntary winding up, because over here you don't have solvency, and if the liquidator is performing its task and there is a preference that has to be given, a priority that has to be made while making the payment for the liabilities, so for that purpose you can have a committee of inspection who would look into the matter, who could guide the liquidator, and who can put a check on the work of the liquidator, right? And when you are appointing the committee, you are appointing it in the meeting when you decide that you want a committee, and in that meeting only the creditors will have to nominate 5 people, right? 5 people, that means 5 creditors to be a part of this committee. And on the other hand, the members will also be allowed to appoint 5 members to this committee. But the appointment of members can be challenged. It can be objected by the creditors. If the creditors at any point of time object the the appointment of the members into the committee, or they may say that okay, we want some other member to be appointed instead of this person, then for that purpose they will have to obtain the approval of the court, right? So both of them, they'll walk into the court and they'll say that okay, this is the vacancy that has occurred, right? Or even if there is no vacancy, this is the committee that we are forming, and the member wants to appoint this person and the creditor is objecting. So the court will have to decide whether he will allow that member as appointed by the members of the company to be the part of the committee, or he would allow the member as per the creditor's nomination, or he can allow some other third person to take charge as the member of the committee, right? And then the committee has no fixed meeting schedule, no fixed meeting tenure, so they will fix the meeting when they meet. That okay, next time we are meeting at this place. Or if at any point of time any if any member of the committee of inspection wants to call the meeting to discuss an important topic, then he can also do that in between. He can call a meeting. So there can be n number of meetings, there can be no meeting. It depends on the case to case specific situation, right? And if they want to call, they can call it at any possible time, whatever they want, right? And when the meeting is called and meeting needs to be held, quorum has to be checked, right? So if the quorum is not fulfilled, which is 1/3 of the total number of members in the committee, then there arises a task, right? And at last we see the grounds of the cessation of the membership. We have 4 grounds. One is the removal, the other is the insolvency or compounding, the other is the absence from 5 consecutive meetings, and the last is the removal. And how will it be filled up? It will be filled up again by the members. The liquidator shall call the meeting of either the contributories or the creditors to fill up the vacancy. So if it is the creditor who needs to be reappointed, they call the meeting of the creditors. If it is member who needs to be reappointed, they call the meeting of the member, right, to fill up those vacancies. And then the members who are still present in the committee, if they are not less than 2, they can carry forward with the work of the committee. So that is all about the committee of inspection under the creditors voluntary winding up that I needed to discuss with you. I hope the concept was clear with you and you remember everything, right? So in the next lecture, we would take up the very interesting topic, that is the comparison between the members voluntary winding up and the creditors voluntary winding up. So with that comparison, the entire concept of the members voluntary winding up, creditors voluntary winding up, as well as the winding up, the compulsory winding up by the court, all these three, all the winding ups, the logics will be very clear, right? So please stay tuned for that lecture. Until then, this is Abhinay Gupta signing off. Thank you.